Hello, everyone. My name is Monica Harper. I'm the Executive Director of the AACFB, and I'm pleased to welcome you to today's webinar on legal matters. Please note that today's webinar is being recorded, so all participant lines will be muted during the broadcast. However, you can submit a question at any time during today's presentation using the Q&A box, and they will be answered by the end of the webinar. Please reserve the chat for communication between attendees so your questions are easily identified by the presenter in the Q&A box. If you have a question and would like to ask your question verbally, please click the raise your hand feature and you will be unmuted to speak. Our presenters today are Dennis Dressler, Julie Ellis, Christian Jorgensen, and Ken Peters with Dressler and Peters Law Firm. And this team has a wealth of information on the commercial finance industry. And I want to thank you all for sharing your expertise with our audience today. This time I will turn it over to Dennis and your team. It's all yours.
Hi, I'm Dennis Dressler. I appreciate everybody's attending this. Hopefully you'll come away informed and a little bit entertained. A little bit about us. The firm has been around for about 20 years. Christian and Ken and I have been partners for about 20 years, and we were partners at another firm before that. Most of what our experience has been in the equipment finance industry almost exclusively. We've been very lucky to have Ms. Julie Ellis join us over the last number of years. I focus my practice mostly on documentation issues as well as other kind of special niche things. Ken's going to speak about bankruptcy. Julie's going to speak about regulatory matters, and Christian's going to speak about litigation. And the views that we're going to express are our own and not the association's. So wanted to dive in a little bit. The first thing that I wanted to talk with you all about is about some of the things that are really popping up on my desk is related to security interest. And most of the deals that we work on, they're either brokered or purchased somehow. Sometimes they're originated, and there's also often reps and warrants that are given about the perfection of the security interest. And with the level of bankruptcies being high like they've been, there's been a number of challenges to security interest that then funnel down to repurchase demands on brokers and originators. So I wanted to take an opportunity to go through some basics with you, give you some pointers and best practices. So kind of the 5-tip routine here, 5 tips to success. What's really important is to make sure that your security agreement and your UCC financing statements match. The security agreement is the language in your contract that says I grant a security interest to the lender. The borrower grants a security interest to the lender to ensure the repayment and performance of all obligations. And the UCC is the document you file with generally the Secretary of State that perfects that grant of security interest. If there's a gap between the security interest language and the UCC1 financing statement language, there's a risk of being unperfected. Let's dial into some of the nuances. So the security interest requires collateral identification. So in the security interest, a blanket, you can say all assets of the borrower. But most of what we do in the equipment finance world is not blanket, although there's a lot of it. But I would say the majority of it is, at least on the small ticket, is perfection as to the individual items that are actually being financed. So grants a security interest, let's say you're doing trucks, grants a security interest in the truck and then lists the VIN number. Grants a security interest in serialized equipment, like farm equipment or road equipment that, it's a 2016 Hyundai wheel loader or something like that. So in your security interest, you have to be precise about what is being granted a security interest in. Now, the UCC1 financing statement, you have a little bit more flexibility. There's a different code section in the UCC dealing with the UCC1 financing statement, And as long as it's reasonably identifiable, you're okay. So in the security agreement, you have to list out the VIN number, let's say, but in your financing statement, you would just identify. It'd be best to identify completely and accurately both the same in the security agreement and the UCC, but there's a little bit more flexibility in the UCC one. Where we're seeing some problems is that people are filing UCCs that say all equipment on EFA number 123, but then they're not attaching the EFA 123. And so courts are holding that that's an improper security interest because you haven't identified with any level of preciseness what the security interest is being granted into. So if you're in the habit of doing, I grant a security interest in all equipment financed under EFA 123, you either need to attach that EFA or you need to go ahead and break down and identify the equipment in the EFA. So moving on a little bit, we've also encountered problems with security interests and UCC financing statements that use the wrong date and wrong information. So if the security interest has a particular date by which the perfection started, you need to accurately list out what that date is. Dates are important because if a court sees that there's a mismatch on the dates, they're more likely than not to hold that there is going to be a perfection problem. And another big concept I wanted to make sure folks were dialing into, and we're seeing this more, is that the UCCs are being filed that have a greater amount of collateral than what's in the security agreement. A very simple case, the UCC financing statement says 10 units and the security agreement only says 5 units. The security agreement is going to control, and you're going to be unperfected on the missing 5 units. So that language has to match up relatively perfectly. Another thing that we're seeing is that there's unnecessary limitations being filed in the security interest. So, for instance, all collateral located in Georgia, or all collateral at the main business location. Unnecessary limitations can make that unperfected. For instance, in one of the cases, the main location had switched from one state or one city to the other city, and the UCC financing statement was overly precise on it, all located at 123 Main Street when they had moved to 456 Main Street, for instance. Court had held that they were unperfected. And what happens then is that the lender, usually it arises in bankruptcy, and the lender gets a challenge from the bankruptcy trustee about the effectiveness of the lien. And if it's determined that the lien's defective, then the lender is unsecured, and then the lender may have recourse against the broker or the originator who repped and warned that the deal that they were buying, that the lender was buying, had a perfected security interest in it. So, 5 best practices that we're seeing right now. Make sure you align the security agreement and the UCC filings. Use clear, consistent collateral descriptions across both documents. If you're going to reference an EFA or something like that, then actually reference that document. My preferred way of doing it with clients is that you don't attach your loan documents to your UCCs, that you actually specify in the UCCs the collateral descriptions from the loan documents. You don't want your loan documents to become a public record, and the UCC financing statement is a public record. And then having a procedure internally to double check. In a law firm, we have multiple people checking it, but have some sort of procedure to double check, make sure. And then if there's any temporal or geographic restrictions on it, think about whether those restrictions are necessary to affect what you're trying to do on the deal. All right, that's what I had on security interest and how it impacts what we're seeing for brokers and originators. I'm going to turn it over to lovely Miss Ellis, who is going to talk on some regulatory matters.
Hi, my name is Julie Ellis. I'm one of the partners here at Dressler and Peters. And I'm going to speak about the Corporate Transparency Act, about Section 1071 of the Dodd-Frank Act, and about our state disclosures. There has been quite a bit of change this past year. The Corporate Transparency Act is also known as the Beneficial Owners Disclosure Act. And what that says is that businesses that are corporations or LLC companies or other partnership type things, that they have to disclose to the federal government who their members are. This has been challenged in the courts. And so in March of this year, the Financial Crimes Enforcement Network, which is who is charged with writing the rule and enforcing the rule, issued an interim final rule. So it could change because it's interim, but is a final rule at this point that removes the requirement for U.S. companies or U.S. persons to report the beneficial ownership information to the FinCEN. It still applies to foreign-owned entities, but for entities that are in fact United States-based entities, there is no disclosure at this time. And we'll keep an eye on that because that may change, although at this point we don't expect it to anytime soon. We've also heard a lot in the past few years about Section 1071 of the Dodd-Frank Act. That required that lenders would annually report information, demographic information about their borrowers and their applicants. The idea was to open up lending to all areas, to all economic and various other communities, making sure that there was no discrimination going on. That has been challenged in the courts, and currently there are 3 cases within U.S. district courts that have put an injunction against the enforcement of that, but only to the plaintiffs in those cases. So because it hasn't been decided by the Supreme Court yet, it was decided by the enforcement agency that they would change the compliance dates and the first reporting dates for the 3 tiers of reporting entities. At this point, and this was done in June of this year, at this point, Tier 1, which are going to be your largest lenders, they now have to have compliance starting in July 1st of 2026. And what compliance means is that they have to start gathering this data. Then June 1st, 2027, they must submit their report. And Tier 2 will begin compliance on January 1st of 2027, with their first report due 1 year later, 1.5 years later on June 1st, 2028. Now, Tier 3, which is comprises your smallest lenders, that's a little different. They get an extra 10 months in which to comply. They have to begin gathering the data October 1st of 2027. But then they don't have an entire year of data before they have to present their first report. That first report is due June 1st of 2028. So we'll keep an eye on that and see how that changes. But at this point, we don't expect there to be any changes in the near future. Now, state disclosure laws are a complete different story. They are, as I've heard many people refer to them, a game of whack-a-mole. We all know that California and New York started the trend They have the two strictest rules, and California requires brokers to be licensed as well as lenders, except for bank lenders and lenders that are covered under the Farm Credit Act. So the interesting thing about all the state disclosures is that because a number of states have enacted their own disclosures, and an even larger amount of states have been considering them in their state legislature for the past couple of years, the Uniform Law Commission, which is who has put together the Uniform Commercial Code, which governs most of what we do in Article 2A leases and Article 9 secured transactions, has developed this year, in fact, this summer at their annual meeting, they have developed a draft proposed Commercial Financing Disclosure Act. And then once they get a finalized version, then they will work toward having the states considering adopting it as state law. But one of the things that the Uniform Law Commission has in their draft, which I find very important for us, is that it exempts purchase money obligations. So if you're financing a truck and you're taking a security interest in that truck, then you've got a purchase money obligation. Also, it excludes leases, true leases. It's somewhat like consumer disclosures because that's where this industry is headed within the regulations, is that they're trying to make these disclosures as close to consumer regulations as they can. But the Uniform Law Commission has specifically left out a lot of the consumer-like disclosures that unduly burden commercial lenders and that just may not be applicable to your sophisticated commercial borrower. The common themes within all of the statewide disclosure laws are that real estate secured transactions are exempt because they have their own requirements within each state and also federally. True leases are exempt. But what is a true lease? So that may be challenged in different states as to what applies and what doesn't. Some states specifically say leases, other ones say true lease. And then they also exclude depository institutions or others that are regulated by other entities such as the Farm Credit Act. Most of the statewide disclosures apply to financing amounts over up to $250,000 or $500,000. However, in New York is 2.5 million. New York has the largest threshold for the regulations. The general disclosures are principal loan amount, total amount financed, interest, the payment schedule, prepayment penalties, and itemization of costs, fees, deductions, and withholdings. But New York also requires the disclosure of how the broker is compensated. We anticipate that the trend in disclosures, laws, and regulations will continue to grow as different states start following each other. You can tell by the map, there's a large cluster in kind of the Midwest and the East. And it looks like my ChatGPT created map may have put an orange spot in the wrong place. It's supposed to be Kansas. So that leads me into what states are currently enforcing or have passed licensing and purchase money obligations. We know California and New York. California requires that brokers be licensed. New York does not. States where Article 2A leases and Article 9 secured transactions are exempt, but brokers are required to be licensed are Connecticut, Louisiana, Utah, Virginia, Kansas, and Missouri. Kansas and Missouri are the most recent ones this year. And then the states where, pardon me, I'm going to take a drink, I have dry mouth. States where 2A and 9 exemptions apply, and they also do not require licensing of brokers, are Florida, Georgia, North Carolina, and Texas, except Texas does apply to sales-based financing, and therefore the brokers that are engaging in sales-based financing must be licensed. The interesting thing is that various states may have exempted the purchase money security interest, but the laws still apply to factoring, to merchant cash advance, to other ways of lending other than taking a security interest in the equipment. And none of them apply to real estate, because real estate all has their own laws. Many states are also prohibiting brokers from charging advance fees. That means, and that includes additional states other than the ones I've mentioned, but also the ones I've mentioned. The fees that brokers are paid for the time and effort that they put into finding the right lender and connecting and doing the paperwork and all that stuff can be on the final transaction and disclosed in New York, but many states prohibit a broker from taking advance fees. So being charged before you engage in trying to find the appropriate lender and make the connection is prohibited. States like Illinois have been batting around various laws within their legislature. They've passed the Senate, not the House, and vice versa in other states. So we do anticipate that more states will be jumping on the bandwagon. A lot of the states are in recess right now, so we don't see any new laws going into the legislature currently. But once the legislatures pick back up again, then they'll probably be discussing these various disclosure laws that the other states have and trying to get on board. There have also been disclosure laws that have been submitted in Congress. They haven't made it out of committee. At this time, there is nothing in committee that looks promising at all coming down at the federal level, which is why the Uniform Law Commission has created their draft version of the disclosure laws. And with this, I will turn it over to Ken Peters.
Well, one final thing about the disclosures is that in a lot of the broker origination agreements, originator agreements with lenders and buyers, there are provisions that I see in many of them, not all of them, but many of them, that the broker undertakes the covenant to comply with all financial disclosure laws. And so that is a trigger for a repurchase demand or some sort of clawback if the broker or the originator does not comply with the financial disclosure laws. And sometimes that liability can be trailing in that you don't know, the lender won't make that demand for a while because they don't know. It takes something to happen. And so there can be a long tail on that. And so I want to make sure everybody is aware that this is what the lenders are requiring. They're requiring covenants to comply with all the financial disclosure laws. Wherever the transaction may be, they're drafted very broadly. And a real world example of how these can play out, Julie and I have been involved in a piece of litigation out in California where one of the lenders was alleged to have not had a financial license and inappropriate disclosures, and it turned into a very big deal. And so missing and not compliance with those financial disclosure laws can be financially just punishing and punitive for originators in those situations. Thank you, Julie. Now our illustrious partner, Mr. Kenneth Peter. Mr. Kenneth Peter is actually one of the guys who was elected or selected to be on the UCC committee to help draft the laws. Ken and I, along with Christian, we've been partners for a very long time. Ken been practicing law. We give him jokes about it for at least 150,000 years. And he's going to talk to us today about bankruptcy.
Well, thank you very much, Dennis. I'd subtract about 100,000 years from how long I've been practicing. Yes, my name is Kenneth Peters. I'm going to be talking with you about some of the fundamental concepts in bankruptcy today in a manner that I hope will help you to make practical and good business decisions and/or will help you to understand what's going on when a bankruptcy case is filed. In particular, I'm going to focus a little bit on the trucking industry because we're currently experiencing what many people have called the Great Freight Recession. I have read, and this is astounding, that in the past 3 years, more than 100,000 trucking businesses have gone out of business. Of course, that may include owner-operators who are very small and who never file bankruptcy or who simply disappear from the scene. Nevertheless, anybody who is involved in brokering or financing or leasing or factoring or MCA agreements concerning the trucking industry is aware of the enormous problems that industry is having. And I myself have been involved in several large cases as well as many small cases. And hopefully, over the next 10 minutes, I'll give you a few pointers for you to kind of understand how to make your decisions from a practical point of view by explaining some of the law. Some of you may already know the law, so bear with me. The first concept I'd like to discuss is the automatic stay. Many of you have no doubt heard of that concept before. What it means is that nobody, whether you're a broker, a lender, or whoever, can take any action to enforce your rights against any of the assets of the debtor or against the debtor itself, himself, or herself. So you guys all know that. And in bankruptcy for trucking companies, though it's particularly important because those are moving assets and those kinds of assets, whether they're trailers or tractors, are not infrequently stripped, removing their value, and in some of my cases have been shipped overseas. It's important to act very quickly as opposed to cases where the collateral that you financed is stuck in one place. What you would want to do is file a motion for relief from stay and or adequate protection. And I'm not going to go into the details of that right now. Just be aware as a takeaway point that when there's a bankruptcy case, you're not allowed, as I think many of you already know, to pursue any of the assets or the debtor until there's some kind of further order of court. Next slide, please. Many of you have no doubt already experienced and know about some of the bankruptcy chapters. Chapter 7, of course, is liquidation, and that can be a no asset or asset liquidation. And essentially, a 7 that's a no asset means that there aren't assets to be distributed to whoever might have a claim against the debtor. As a practical matter, not a legal matter, but as a practical matter, in my experience, the differences for people in the industry between a Chapter 13 and a Chapter 11 are usually not significant. Chapter 13s, though, tend to be for very, very small companies and for individuals, and Chapter 11s are for bigger reorganizations. But I think of a Chapter 13 as a miniature Chapter 11 to a lot of extent. Now, from the point of view of how to handle it legally, there really aren't a lot of differences from the practical point of view. Let your lawyer or your advisor explain the nuances there, and we won't get into the legal differences, but you still have the automatic stay, of course, still applies, and you do have the opportunity to remove the automatic stay to either in a Chapter 11 get adequate protection payments, which in theory is to compensate you for the diminution in the depreciation, but you usually can get more than that. In a Chapter 13, you don't get adequate protection payments, but instead the plan payments are supposed to, in theory, commence immediately upon or almost immediately upon the filing of the plan. I know this is a lot to throw at you, but I'd like you to think in terms of what I'm telling you to be issue spotting, a framework to think of things, even if you don't quite understand all of it from my point of view as a lawyer. Let's move on to the next slide. The next two slides, this being the first one, are really the most important slides for me to try to assist you in handling bankruptcies, whether you're a broker, a funder, whatever your station in the industry is. The first thing you do is find out when there's a claims bar date, because if you blow the claims bar date, then 95% of the time you're blank out of luck. In other words, you can't file a claim late. So jump on your bankruptcies quickly. The second cheat sheet item is for you to determine if you have a secured claim. What's the valuation of the collateral you have? Are you oversecured? Occasionally you are oversecured. In those unusual situations, you're often entitled to default interest as well as attorney fees, even though it's a bankruptcy. So what's the valuation? Sometimes it's a good idea to let the other side, the debtor, determine a valuation because it's not unusual. I'd say maybe at 1 out of 10 cases where the debtor actually values the collateral more than you would. So 90% is not true, but sometimes it does. So be careful. Then the third factor, is it a true lease? There are different rules in bankruptcy that apply to whether or not something's a true lease. So if you provided, let's not call it collateral, let's call it equipment that is subject to a true lease, then there are a lot of advantages in bankruptcy. And I noticed that in our industry, when I first started in the industry, the trend was from true leases to sales. Now, in the past 3 or 4 years, especially with all these new laws being passed that Julie referred to, there's a trend back to true leases. Of course, accounting, whether it's GAAP accounting for your balance sheets and net income statements, or it's tax accounting, which isn't always the same thing. You have the issue of a motion to assume or reject the lease if it's a true lease. And at the risk of repetition, what is a true lease for GAAP and what's a true lease for tax accounting isn't always the same, though it's usually the same as it is under the Uniform Commercial Code, where your attorneys are enforcing your lease rights in bankruptcy or outside of bankruptcy. A true lease means that you have a meaningful residual interest at the end of the lease term, which most of you know already. And if you don't have a meaningful residual interest at the end of the lease term, it's usually a sale, whether or not the document is called a lease. Perhaps too much information, but we'd be happy to answer any more questions about that. And it's all outlined in 1203 of the Uniform Commercial Code. Let's go to the next slide. The next step to consider is how you're scheduled in the bankruptcy schedules. Sometimes the bankruptcy schedules can provide you with a basis for the argument that you want to make, such as, for example, you might be included as a true lease in the schedule, which is usually preferable in bankruptcy, even if you think that there's a good argument that you're not a true lease. So pay attention. Then the fifth cheating point is, can you request adequate protection, relief from stay, which is when it's a sale, when it was a sale as opposed to a lease? Can you file a motion to assume or reject when it is a lease? And then the sixth cheating point is something that most people don't realize is that for Chapter 11 cases, which is the reorganization for larger bankruptcies, and there's different types of Chapter 11s, but generally think in terms of the fact that you should usually, not always, jump on how you're going to be treated. Because when what is called first day motions, cash collateral orders, and I won't explain what that is, just remember it happens near the beginning of a bankruptcy, is a good time to try to argue with the debtor's attorneys to have you included as an adequate protection payee to get paid adequate protection payments right from the beginning. Is the bank secured at least in part by cash collateral, such as by a blanket lien? I think that's probably a little beyond what we're talking about today, but those are issues that your attorney should look at. And then under Chapter 11, you have to consider whether or not it's an equipment financing agreement, a leasing agreement. Is it a working capital loan, which you guys usually don't deal with? Is it a revolver loan, which you guys don't usually deal with? Is it a merchant cash advance? Maybe some of you deal with it. Is it factoring? Is it a real estate loan? And treatments are different. Now let's go to the round. Let's finish it up. Let's go to the next slide. This is a true, real Chapter 13 plan. Of course, I'm joking, but Chapter 13 plans, when they're first filed, are often really poorly written. And keep that in mind. You should feel if the monies are too small, you don't want to hire an attorney, read the plan and then call the attorney for the debtor. And I'm not necessarily recommending that. That's a business judgment call, but they are very confusing and often very poorly written for the first one or two plan iterations. Let's go to the next slide. Then there's something called the cram down, which I alluded to earlier, which you might not realize, but that's the difference between essentially, I'll put it in business terms, what do you do versus how much are you going to be, what is due to you versus how much you're going to be paid. Usually the collateral or the equipment is worth, not always, but often it's worth less than what you're due to be paid. And the payment to you in bankruptcy is usually based upon the valuation, and the valuation is usually less than what you're due to be paid. And what's so frustrating, was certainly frustrating to me when I was in business, is understanding and navigating that issue of how much are they going to push down on what you're going to get paid. And then finally, last slide. Going back to Dennis's talk and foreshadowing Christians, remember the paperwork is the key to enforcement. If everybody was going to do what they were supposed to do and are supposed to do and always paid you, you could just have a handshake and save tens of thousands of dollars a year, perhaps, on attorneys. Notice in this cartoon, it says, did you notice the scratch out of the $1 buyout for the end of the term and the evergreen clause, which is an automatic renewal, which is in 6 font. So consider the documentation upon which you are relying. And in this cartoon, it says, if you read the small print, you'll see that the 95 miles to the gallon was only when the car was being towed. Now, would a court enforce that? Probably not. But I, as a good attorney, could certainly make some good arguments in favor of enforcing that clause. So now I'm going to turn it over to Christian.
One last point on the bankruptcy and that we see is that bankruptcy moves about 1,000 times faster than a normal court case. And so the first day motions that Ken was talking about, oftentimes that comes with the bankruptcy notice itself. And so in a more complex case and the higher dollars owed, you really want to pay attention to those first day motions. Oftentimes the relief is interim for like 7 or 10 days, maybe 14, something like that, before it goes final. So it's really critical that you get into, you review, you get it to the appropriate person, whether you're in-house, external counsel, or some other person about bankruptcy. Similarly, proof of claims, when Ken was talking about 95% chance that you're blank out of luck, those dates come fast and furious. Discharge dates come fast and furious. So bankruptcy is date driven and it is on a rocket docket. It really moves. So people who are accustomed to state court litigation sometimes have a hard time mentally transferring or pivoting to the speed by which bankruptcy can happen. And as Ken alluded to, that if you miss dates in bankruptcy, it's not like state court where you can go back in and say, hey, Your Honor, we missed this date. You're barred from taking in further action. And if you don't file that proof of claim timely, you don't file your discharge action timely, you're totally barred. So just note to everybody on the call that bankruptcy moves so fast, and to take that into account. Next, we have the fabulous Mr. Christian.
Well, thank you very much. I'm last for a reason. Please allow me to introduce myself and have some sympathy and some taste. I'm Christian. Sorry for the Rolling Stones pun, but that's often what the litigators are considered. I'm Christian Jorgensen. I have been working with these folks for a very, very long time. If the deal ends up coming to me, something went wrong. Now, typically, things were papered correctly, and we just have an individual who didn't pay, or their business went south and their business plan didn't work out well. But what's most aggravating, and what I see more and more of, comes down to what this last slide is, and that is sloppy writing, sloppy paperwork, hasty paperwork, deals that do not include certain critical elements that really become key if litigation is concerned. Now, we're talking about simple things: choices of law, choices of jurisdiction, waiver of jury trial, integration clauses. So folks can't come back and say, well, we had a different deal, and that's not necessarily what's said here, so there's really an ambiguity. Anything that they can come up with. But typically, the longer litigation is directly related to what the paper says. All I have when it comes to my desk is what was written and what was signed. And it's imperative that this slide is taken seriously, because if it's missing one of those clauses, if it's inconsistent with the UCC, as Dennis had talked about, with the description of the collateral, if we don't know where necessarily to sue, and things of that nature, or we leave the door open for possible affirmative defenses that just prolong and protract litigation, there's a real problem. And all of these things can be avoided by the things that you just heard from my colleagues, who know very, very, very well. But too often than not, it does happen. And that's what I'm left to clean up. So I would say that, I mean, from my point of view and my 25 years in doing the same thing and working in the same area, is that what your end result is going to be 99% dependent on what it is that was drafted. And I'm not trying to necessarily push the need for folks like us, but an ounce of prevention is worth a pound of cure. Because if it is papered correctly, if the correct clauses are there, it makes litigation much more solid, and you can be much more confident in the outcome. If it's not, it's bad. I mean, still deal with folks now who are in a hurry to get something done, and we really want to grab this truck. This is great. We already have a lessee for it. Let's get this done. And they, somebody just writes out a simple, bill of sale, and it has no other requirements in it. It's just, this is it. Well, that's not sufficient. And in the last case that I just finished, that's what it involved, and it was just hasty. And because of that, it cost a lot of money to rectify. So as the last person to speak here, because I am the last resort, and when things go south, you make your life a heck of a lot more easy, as well as mine, which again also makes your life easier, if it's done right the first time. So spending that extra time consulting with either your colleagues or your attorneys, as to whether or not the documentation is papered correctly and contains correct clauses, and is consistent, is going to take you very far. Nobody ever wants to be on a losing end of a deal that they brokered themselves and didn't consult with others on, that went south, and now they're in a litigation position where it's not looking good, or they're looking at spending a lot of money on something they shouldn't be spending a lot of money on. So I guess my speech here is doom and gloom, but it can be avoided, and it can be avoided by you all. And it takes a little bit of extra time and a little extra precaution, but it does work. Myself, I mean, typically we work on a lot of deals that are above $75,000, which is the threshold amount for federal jurisdiction, and a diversity case. And I prefer to be in federal court if I ever can, because state court is utterly unpredictable. You never know who you're going to get. For instance, in Indiana, there's 92 counties. And the farther south that you go, the more different it becomes. And most, and I can say this confidently, I think Dennis would probably agree with me because we've litigated a lot of cases together, and so does Ken and I. Most are not well versed in the UCC. They are not well versed in collection, especially collection. And federal courts are just as bad at the collection aspect as well. They just don't know, and because they've never dealt with it. So it makes it difficult, but we do try to stay in federal court if we can. If we can make it above $75,000 and there's diversity there, that's where we go. It's predictable. If you know the rules backwards and forwards, and you can recite them in your sleep, and you wake up and you say them, and your wife hits you, then you know what's going on. But at least you know how to deal with it. So we try to stay there if we possibly can. I don't want to put words in the mouth of my colleagues, but I think they would probably agree with me as well, on that. And of course, bankruptcy is always federal court anyway. But I guess besides whatever questions and answers there's going to be, because I see we're running out of time, that I'm happy to entertain. It's everything that they have said beforehand, take to heart, because again, if it ends up on my desk and we start litigation, there's no going back from what it is that was originally written. So that little bit of extra time in the beginning pays dividends. Thank you.
Thank you, Christian. We wanted to reserve a little bit of time if there's any questions that we can respond to.
Yep. We do have a few already. And just as a reminder, put your questions in the Q&A box and we'll get them answered as best we can. And, please keep them kind of generic, not something specific to your specific situation. Let's see. First question is, will the license requirements of different states be compiled and distributed to brokers? I know that's a moving target. Does such a document even exist?
I think that would be something that the associations would probably put together. Your own attorney could put it together for you as well.
I know that ELFA has a page on their website where they have different, I don't know how extensive it is though. Just has a picture of the country with which states have those, but I don't know if it drills down into exactly what brokers need to be aware of. So we'll look into that. Will there be a general area within the AACFB for templates of disclosure documents? Again, I don't know if that is something that can be.
I can address that. Like New York or California in particular, when they came out with the regulations, they had essentially, they did not have the forms, but they had the verbal instructions to complete the forms. And initially it was a matter of interpretation of the regulation to have extrapolated to an actual form. I think though that enough time has seasoned and that there's now consensus around what that form looks like. I don't know if there's a general area in the AACFB website that has that though.
In California, they are very minute in what they want these disclosures to look like. You read through the rules. They don't, as Dennis said, they don't give you a template to use, but they tell you the font, they tell you the columns, they tell you the rows. Other states do not do that. They'll tell you what you have to disclose, and they will include how you determine what that is, but they won't specifically have it in terms of size, font, columns, that kind of thing. As far as I know at this point, there are no generalized templates, primarily because the laws are changing. And again, that would be something through the various associations if they wanted to do that.
With an automatic stay, are you still able to continue collection efforts, or is that a cease and desist from those efforts?
It's essentially a cease and desist. You have to go to court to get permission to continue. However, you can pursue a personal guarantor if your borrower files.
Okay. When is the valuation as of when the BK occurs, or as of the final negotiations in terms of what the value is? This time, maybe 6 to 12 months by the time the judge decides on the value. What is standard in terms of this?
That's a superb question, and there's a diversity of opinions throughout the United States. It rarely is litigated, but some of the opinions, when it is litigated, say it's at the date of the petition. Some say it's at the date of confirmation, or even the effective date, which is usually about a month after the confirmation. What I do as a practical matter is I look what's best for my client. So look what's best for you and then go with that.
And then there's also valuation based on what proceeding. So
That's right.
Initially, when you file a motion for relief from the stay, you have to disclose what you think the value is. And that's usually in the beginning of a case, and you want to use the lowest value. You want to use the liquidation basis sometimes. In contrast, when you get to plan, then you want to value it on a fair market value, going concern value, because that generally in valuation methodology results in the highest valuation. So what it's being valued for and the timing are interrelated in a way. So different valuations as of different times, depending on the context.
And I would just add to that that those legal niceties and nuances are extremely important when your attorney is advocating your case or when you're advocating for your case. But as a practical matter, just go with what's in your best financial. This is my non-legal counselor advice. Go what's in your best financial interest to the extent you can ethically and according to the rules get away with it. So if you want a really high valuation and it's justifiable, you can't just make up stuff, obviously, because you want to have a realistic basis. Go with what's in your economic best interest is what usually I recommend, as long as there's a legal basis that's in good faith that you could promote to support your economic interest.
How does a title lien compare to a UCC filing? Do they carry the same weight?
Yeah, I can help out on that. So title lien and a UCC are the same thing. They function the same way. They are intended to do the same thing, which is to provide this concept of perfection. A title lien is on equipment that has a VIN and that's certificated. So certificates of title, cars, trucks, boats, things of that nature, you perfect by notation on the title. Things that are not titled, such as trucks, loaders, or I'm sorry, wheel loaders, forklifts, a lot of construction equipment, you perfect by filing a UCC-1 financing statement with the Secretary of State. So they do, to answer the question, they carry the same weight, but they're used for different collateral. And the primary difference that I can come up with is that the states derive income from titles, whereas they don't, a lot of states don't derive income from the UCC filing. So you have to renew your titles, you have to your cars and whatnot. And so there's this separation between different types of collateral. Inventory is another example. That's titled in a slightly different way with UCC filings. But they mean the same thing. It's just they apply to different collateral.
And if I could just chime in for a second there on that, it is extremely important to know whether or not your collateral is certificated or not. Because if it is, and you need to be on the title, that's the way you perfect. And if you don't, that's going to be an issue. I've actually run into this issue several times with clients who've received titles or older titles from folks that were buying equipment from and wanting to lease to others, and they didn't spend the time to procure the actual title from the Secretary of State to see who the lien holders were on it. And when you see a taxing authority or you see another bank or something like that, it's a real problem, right? Because they're going to want their money. So you do have to be very careful in finding out and getting the most accurate information on the title that you're getting, and whether or not this equipment, whatever it might be, can be or is certificated or it's not.
Excuse me. My lease companies send out all the paperwork on deals. What type of document do I need to issue on each lease deal?
Interesting question. So at a bare minimum, to qualify under UCC 2A, you need a lease agreement that has critical information. You need the lessee, you need the lessor, you need the term, you need the rate, and you need to deal with the end of term, whether it's a renewal, evergreen, purchase. And if there is a purchase, it's not absolutely required under law, but it's very, very recommended that you have some kind of methodology stated in that purchase option. For instance, the most common one is fair market value. I like to use fair market value installed, fair market value going concern, trying to maximize the value at the end of the deal. Now, if you have a track lease, then that track lease requires an additional set of documentation about what happens at the end of term. And a track lease, as many of you know, has essentially a formula for dividing up the depreciation. Another document that's absolutely essential on leases is a delivery and acceptance certificate, and that ties in with the 2A hell and high water clause. Beyond that, the authorization documents, the corporate consents or the LLC consents is another document I would think would be mandatory. And then another document that I think is mandatory, well, it's not mandatory under the law, but it's mandatory under good business practices, is that there's a security interest granted in that lease in the event that what Ken and Julie and Christian were talking about, if it gets reconsidered to be from a true lease to some kind of financing agreement, you want to have plan B. And without that plan B, if you get challenged, then you're lending on an unsecured basis. Also, if it's not true leases, what Julie was talking about, you need your disclosures.
That leads into the next question. Do brokers need a broker license in each state or just their home state?
That depends on the state that you're doing business in. Some of the states with licensing requirements have it applicable to out-of-state brokers or lenders doing business within their state. Other ones do not. So it's a state-by-state regulation.
For instance, California, I think they have this this nexus approach to whether or not disclosures are required. So you look to where the headquarters are or the NERF center. And if either of those are in California, it's a California deal and you need to have California licensing and disclosures, even if the broker is in New Hampshire, for instance.
And it's that way with the states that have out-of-state licensing requirements.
You don't make it easy on us.
They do not, but consult your counsel and definitely work with them on all the states that you want to do business in.
Does a pre-delivery acceptance count as a certificate of acceptance if you fund prior to customer having the equipment? If a lessor does pre-fund, do you recommend going back and getting a final acceptance signed, even though the pre-delivery acceptance document has hell and high water language and that the lease has commenced?
I can take this one. I love this one because it was pre-funding has always been around, at least in my 30 years. But what we saw during the pandemic is elevated those concerns more so than they have been, and they've been elevated since. In that many vendors are now demanding full payment before they'll do anything. Or they, for instance, on a truck, before they let that truck off the lot, they require full funding. And so we do these pre-funding certificates, and we've now embedded them into a lot of the EFAs and the leases with respect to with respect to the commencement date, the date by which the customer becomes obligated for the full term of the deal. And then we combine that with a DNA delivery and acceptance certificate that basically says something like, I've either received it or I feel confident enough in my reasonable business opinion that I'm going to confident enough because I've selected the vendor, I've selected the equipment, and that I want this lease to commence even though I haven't received full possession of it. So we've modified in connection with those different moving parts, we've modified that DNA to incorporate those considerations if it is a pre-funding deal. To date, it's been challenged, I don't know how many times, but it has held up. I've not had a case where the pre-funding in a commercial deal, only in commercial, and we only do commercial work. It has been, the challenge has been successful. In every instance, it's not been successful for the reason that, if it's drafted fine, like, I'm exercising my own business judgment. I want this equipment. I understand the vendor wants to be paid in full. And if the company pays the broker, if somebody pays the vendor in full, then I'm going to be responsible for it. And any problems with it, I'm going to go to the vendor, not the lender.
I'd like to just add one 30-second comment to that. I agree with everything that's been said. I've drafted several transactions for different companies with pre-funding agreements. Different companies have different desires as to how that pre-funding is paid back. However, the most important point is that your transaction should essentially state that once you pre-fund, come hell or high water, you're absolutely unconditionally, without any waiver of any kind or nature, you must pay the funder or the broker or whoever. In other words, just paper it. Once you paid, the hell or high water provision becomes activated.
All right, great. And one last question. Which department handles equipment lease broker license in most states?
There usually is a separate department that will handle it, and they handle all licensing, so consumer and commercial, real estate and personal property.
Right. Well, I know we've gone over time, but we've had a lot of great information and great questions. And I want to say thank you to everybody for participating. Thank you all for your expertise. And this webinar will be posted on the members only section of the AACFB website if you'd like to go and review it at any time in the future. Thanks again, everybody, and have a great day.
Thank you.
Thank you for the time.